Hello and welcome to the Entrant. The topic for today's discussion is one of the most relevant topics under the Indian family laws. The sources and schools of Hindu law holds great importance when it comes to questions asked in competitive exams. Let us start off by understanding a little about the history of Hindu law. Hindu law is roughly 6,000 years old and is considered to be the most ancient and prolific laws in the world. It was primarily established by the people to form a code of conduct that needed to be adhered to in order to attain salvation, and not for the purpose of ridding the society of crime or transgression. It was later developed to satisfy the needs and welfare of the people. Broadly, there are two types of sources of Hindu law: traditional or ancient sources and modern sources. We will be discussing them shortly. The primary ancient source is Shruti. The word is derived from Shru, which means to hear, and refers to the words of gods itself. Shrutis are the sacred or pure utterance that has been enshrined in the Vedas and the Upanishads. It is considered to be the primitive source containing the knowledge of the law, salvation, and incarnation. It is believed to be the language of gods through the sages. The Vedas provides information on rights and duties, forms of marriage, partition, and inheritance of property. They also provided for the division of the society into the four varnas, that is, the Brahmin, Kshatriya, Vaishya, and the Shudra, and the stages of a person's lifetime into various ashramas, the Brahmacharya, Grihastha, Vanaprastha, and Sannyasa. The four Vedas are the Rig Veda, Yajur Veda, Sama Veda, and Atharva Veda. The Shrutis consist of the Vedas and their Sanhita, which is the hymns, the Brahmin, which tells us the duties and means of performing them, and the Upanishad, which elaborates the essence of the duties. The word Smriti has been derived from Smri, which means to remember. Technically, Smritis mean those works which are created by the virtue of memory of the sages, texts which have been remembered and then interpreted by the rishis throughout the generation. Some of the notable writers enumerated by the Yajnavalkya are Manu, Brihaspati, Parshahar, Vaisya, etc. They have been further classified into the Dharma Sutras and Dharma Shastras. The Dharma Sutras, in prose form, deal with laws and rituals, administration of the state, the duties of the king, and laws. The Dharma Shastras, on the other hand, mostly deal with customs and practices, for example, the Manu Smriti and the Brihaspati Smriti. The third ancient source of Hindu law that we will be discussing today are the digests and commentaries. A commentary is an explanation or the interpretation of a particular smriti, whereas the digests are materials from all smritis. Commentaries and digests have expanded the scope of Hindu law and played a major role in developing it. The evolution of different schools of Hindu law is a result of these digests and commentaries, as they are different interpretations of the Smriti. Dayabhaga and Mitakshara are considered to be the two most important commentaries. The last ancient source is custom. A custom is a tradition that has been practiced in society since ancient times. It is the type of practice which is under the continuous observation of the people and has been followed by the people, and which now has become a governing norm in that particular society or community. It refers to those crystallized practices which are followed by a community or a group of people for a considerable period. They have been classified into local customs, caste and community customs, and legal customs. A local custom is followed in a particular geographical area, whereas a caste custom prevails within a certain community of people. Legal customs, on the other hand, are enforceable or sanctioned by law. It can't be deemed invalid until the law itself declares it invalid. The first modern source of Hindu law are the principles of equity, justice, and good conscience. Equity means being fair and implies a fairness in dealing. These principles are called natural law principles and is the basic rule of law. This rule of law applies when an existing law does not apply in a case before the court, and the court decides the particular matter by applying its rationality and the concept of justice, equity, and good conscience. So, wherever conflict arises in the interpretation of Hindu law, this principle is used by the courts either to formulate a new law or to carry forward existing laws. In such cases, the courts are guided by the principle of reasonableness, basic values, and fair play. The next modern source is legislation. The legislation is an act of parliament that plays and provides a base and authenticity to the laws. It acts as a tool for social change, and the parliament, in accordance with the needs of the society, constitutes new laws. It has been stated that in order to meet the new conditions of the society, it became a necessity to codify personal laws in the post-independence era. Examples of legislations include the Hindu Marriage Act of 1955, the Hindu Succession Act of 1956, and the Hindu Adoption and Maintenance Act of 1956. The last modern source is precedent. The doctrine of precedent was established and is applied in the cases resembling the same facts and circumstances of a case already decided. Judicial decisions are authoritative and binding on lower courts. This hierarchy of courts was established by the British rule. Practically, all the important principles and rules of Hindu law have now been embodied in case law. In such matters, recourse to the source is not necessary. Reference to a leading decision is enough. The concept was introduced to the doctrine of stare decisis in British India. By the principle of judicial interpretation, doctrines, principles, and rule of law stand modified or altogether new principles, doctrines, and rules have been introduced in the body of Hindu law. For these principal doctrines and rules, the sources of authority are the precedents. Schools of Hindu law originated from a multiplicity in interpretations of the commentaries and the digests of the Smritis. These schools have widened the scope of Hindu law and explicitly contributed to its development. Originally, there were no schools of Hindu jurisprudence. Schools of Hindu law came into being when different commentaries appeared to interpret the Smritis with reference to different local customs in different parts of India. The two major schools of Hindu law now are Mitakshara and the Dayabhaga. The Mitakshara school is one of the most important schools of Hindu law. Its name has been derived from the commentary of the Smriti written by Yajnavalakya. The jurisdiction of the Mitakshara is supreme throughout India, except in Bengal and Assam. The Mitakshara is further divided into four schools established in different parts of India, namely Dravida School, Bombay School, Banaras School, and the Mithila School. The Dravida school prevails in the southern part of India, which includes the states of Tamil Nadu, Kerala, Karnataka, and Andhra Pradesh. The main authorities of these schools are Smriti Chandrika, Saraswati Vilasa, and Vyahavara Nirnaya. The Bombay school includes the western part of India and the states of Gujarat and Bombay. The Banaras school covers the whole of northern India, excluding rural Punjab. The main authorities of these schools are the Viramatrodaya and the Nirayana Sindhu. The Mithila school revolves in the areas of Tirhut and in some parts of northern Bihar. The Dayabhaga school is based on the inheritance law based on the principle of spiritual benefit. The term Dayabhaga is derived from a similarly named text written by Jimutavahana and predominantly prevails in Assam and West Bengal. It primarily deals with partition, inheritance, and the structure of the joint family. This digest is aimed at eradicating all shortcomings and limitations of the previously established principles and other artificial principles of inheritance. There are some key differences between the Mitakshara and Dayabhaga school when it comes to the joint family, partition, rights of women, and widows' rights. The joint family. According to the Mitakshara law, school, a joint family refers only to the male member of a family and extends to include his son, grandson, and great-grandson. They collectively have co-ownership or co-parcenary in the joint family. Under the Dayabhaga school, the son has no automatic ownership by birth but acquires it on the demise of his father. Under the Mitakshara school of law, all the members of the joint family enjoy co-parcenary rights during the father's lifetime. Under the Dayabhaga school, when the father is alive, the sons do not have co-parcenary rights but acquire it on the death of the father. In the Mitakshara school of co-parcener share is not defined and cannot be disposed of, whereas in the Dayabhaga, the share of each co-parcener is defined and can be disposed of. When it comes to partition, the Mitakshara school, the intention involves holding the property is defined by definite shares, while the Dayabhaga school, there has to be physical separation of the property into specific portions and assigning of separate shares to each co-parcener. In the Mitakshara system, none of the members of the co-parceners can claim a definite physical share of the joint family. In the Dayabhaga system, each of the co-parceners has a definite share in the joint family property, even though the family is joint and undivided and the possession is common. When it comes to the rights of women, in the Mitakshara system, the wife cannot demand partition. She, however, has the right to a share in any partition effected between her husband and her sons. Under the Dayabhaga, this right does not exist for the women because the sons cannot demand partition as the father is the absolute owner. When it comes to widows' rights, when one of the brothers dies, his widow can succeed to his share under the Dayabhaga, but under the Mitakshara, her rights are excluded by the right of survivorship of the brothers. The widow can then have only a right to maintenance. I hope this video was helpful in providing a simple and clear understanding of the sources and schools of Hindu law. For any further queries, please drop your questions in the comment box below. Please like and share the video and subscribe to our channel.